In this edition of the Better FAQ videos, we're talking about common law trademark rights. Now, trademark is a pretty involved and pretty nuanced area of the law. I've got a few other videos on trademark that generally explain the process, what trademarks are, what good evidence of use of trademarks would look like. This video is specifically about common law rights. Now, when you think about trademarks, you can think about the rights that you have on a spectrum. And the high end of the spectrum is going to be United States Patent and Trademark Office trademark registration. So that is when you file with the Trademark Office, you go through like a 12-month process, sometimes shorter, sometimes longer, and you get registered with that office. You have a trademark certificate with a little gold seal on it for specific products and services. Now, common law rights are going to be on the low end of the spectrum. And the low end of the spectrum still does provide rights, these common law rights, but they are not as strong as your registration with the USPTO, the United States Patent and Trademark Office. So what does that mean? What is the difference between the rights? Well, at the high end over here, when you have your registration, you are the only person or business, however you registered the trademark, to have the exclusive rights to use your trademark with the products and services you registered it with in the entire United States. It doesn't go outside of the United States. This is the United States Patent and Trademark Office. But every state in the country, no matter where in that state, no matter how someone else is doing business, if they are selling the products and or services that you are, and they try to use a trademark that is confusingly similar to yours, they're infringing. This is when you have a trademark registration, of course. Now, common law rights. Common law rights, unlike when you register with the USPTO, you don't have to do anything for your common law rights other than use the trademark with those products and services. So let's say that I was selling flip-flops and I wanted to name those Sam's flip-flops. So I go out and I put up a stand on the corner of the street and I start selling flip-flops, which you would need a permit for that. That's not for this video. Anyway, I set up a stand out there selling Sam's flip-flops illegally, and I then want to make sure that I'm protecting that trademark. Well, because I've already sold flip-flops from Sam's flip-flops, I now have what are called common law rights in my geographic location. Now, of course, like anything in the law, what that geographic location is and its radius is a pretty debated topic these days in the law. And the reason for that is that, let's say back in the day, Sam's flip-flops, if I opened a brick and mortar shop, I just went to a strip mall and I rented a space and I put Sam's flip-flops on the light up neon sign and people were buying flip-flops out of there. Well, that is going to be my geographic region, that neighborhood, maybe that city, maybe even that county. But if there are other people that are using Sam's flip-flops and they were using it before me, so let's say just down the street, there's another Sam's flip-flops, and they've been there for 10 years. I no longer have those common law rights, and in fact, I never did. And the reason for that is that somebody that uses a trademark first for the same products and services has the senior rights. This is a little bit of a digression for this video, but it's important to give the context because your common law rights are going to be yours once you use that mark in commerce by selling your products or services, but only if you're the first one to use it, which is why a trademark search is so important before you start doing anything under a trademark. There's other videos on the trademark searches in our playlist. But the point here being is that with common law rights, you have sort of informal trademark rights. And what are trademark rights? Probably worth covering. I'm going to do it quickly here because it's covered in my other videos, but when you have rights to a trademark, it means that you are the only one that can use that trademark with your products and services wherever you have it protected. That means that if somebody else starts using a confusingly similar mark, you can go after them and say, hey, that's mine, you can't use that. If somebody comes after you and says, hey, that's mine, you can't use it, but you have trademark rights, you can tell them, no, this is mine. But keep in mind, again, that that is a very involved question of whether or not someone has the senior rights. Typically, the easy way to put it is whoever used it first in commerce does. But if you get a trademark registration, that means that you, no matter if somebody used it before you, it means that you have the right in the entire country to use that trademark with your products and services because you went out and you took the steps to register with the USPTO, even if somebody that used it before you has had it longer than you, but they didn't go to the USPTO, then they don't have those rights. But this video, common law rights. Let's go back to that and let's make sure it's clear before we wrap. Common law rights are automatic when you use a trademark publicly with your products or services, but they only extend to your geographic region, or sometimes the debate, some people will say it extends to where you've made sales, which is why these days it is a complicated analysis, because these days, with the internet and selling things online in e-commerce, you can make sales in Amsterdam, and you can make sales in New York, and LA, and Arizona. Now, in that example, you certainly wouldn't have rights in Amsterdam or anywhere abroad because our legal system is ours. But you have a good argument that you do have legal rights to that trademark in those places that you sold, Arizona, LA, New York, because you have a presence there with that trademark and have made a transaction in commerce with that trademark. Now, common law rights, that's not what you want to rely on to go to someone and say, hey, I have rights to this trademark, because they are informal and they're at the low end of the spectrum, remember. So that's why trademark registration is so important. However, keep in mind that you can still use common law rights in some scenarios, certainly in your geographic region if somebody else is using a mark similar to yours in that region. So, common law rights. It's the low end of the trademark protection spectrum, much less significant and strong than if you have a USPTO registration, and it generally extends to your geographic region. However, there is confusion around that nowadays with e-commerce, which is why it's not great to rely on common law rights. But sometimes, if there are already registered trademarks similar to yours, but they may be somewhere else in the US, that might be your only option to rely on common law rights. But keep in mind, in doing so, if there is that other trademark registration, you are technically infringing on that other mark. So it's a roll of the dice to rely on those common law rights if you know there are other trademarks out there already. At the end of the day, common law rights, informal, some protection, trademark registration, very formal, all the protection, but only in the US. Thanks for tuning in.